Government officials operate behind a powerful legal shield. Sovereign and official immunity protect state and federal actors from being personally sued for actions taken while doing their jobs. But if a litigant can successfully prove that an official's legal authority is an illusion, that shield breaks. A recent legal filing titled Questions for Federal Court attempts exactly this maneuver. It is a calculated set of arguments designed to dismantle a judge's jurisdictional power from the ground up. We are going to map the precise legal syllogism this document uses to strip government actors of their immunity and expose them to personal liability. Whether this specific argument succeeds or fails, analyzing its architecture tests the exact boundaries of constitutional power and state protection. The author's opening maneuver is designed to corner the state court. The document begins by demanding acknowledgement of the Supremacy Clause. It cites the 1901 case Downs v. Bidwell, establishing that the U.S. Constitution does not yield to local circumstances or treaties. The filing asks a pointed question: does any state or federal judge have the delegated authority to ignore the rulings of the U.S. Supreme Court? The question is a logical trap. By forcing lower courts to admit they are strictly bound by the Supreme Court, the author locks them into adhering to specific 19th century rulings regarding unconstitutional actions. Establishing historical case law as the binding authority for lower courts provides the foundation the author needs to trigger the immunity strip. Node 1 of the document's legal flowchart relies on the 1886 Supreme Court decision Norton v. Shelby County. First, it defines a de jure office. This is a lawful government position explicitly created by the text of the United States or state constitution. The text contrasts this with a de facto office, any position that lacks this explicit constitutional enumeration. The author details the specific ruling from Norton. An unconstitutional act creates no office, imposes no duties, and affords no protection. This leads to the document's legal conclusion. Public functionaries occupying these de facto offices are usurpers acting outside the rule of law. The text claims to possess certified FOIA evidence, proving a specific official is occupying one of these void de facto positions. Premise A establishes the baseline. If an office is de facto, its actions are legally non-existent. The official occupying it holds no inherent authority to rely upon. The document then targets the limits of the 11th Amendment, moving the focus to the vulnerability of the individual actor. To do this, it introduces the 1908 precedent Ex parte Young. This case deals directly with state officers who attempt to enforce unconstitutional statutes. Ex parte Young outlines a specific legal reality. A state cannot impart immunity to an official who violates the superior authority of the U.S. Constitution. The mechanical result is immediate. The official is legally stripped of his official character. The filing brings in the 1974 case Schweier v. Rhodes to reinforce this exact stripping mechanic in modern case law. The author leans heavily on one specific phrase from Schweier. The offending actor is subjected in his person to the consequences of his individual conduct. Premise B makes state immunity conditional. Committing an unconstitutional act instantly severs the individual from the state's protective shield. With the theoretical framework built, the author points to the specific modern action they claim triggers the loss of immunity. The court grievance centers on the courts categorizing men and women who challenge public authority with the label sovereign citizen. The document claims this terminology stems from a 2011 FBI report, which is used to demonize and prejudge individuals in the courtroom. The author argues this federal labeling contradicts decades of congressional intent and presidential proclamations, spanning from FDR to Trump. The author legally categorizes the use of this term as an active deprivation of unalienable rights. The filing alleges that court administrators issue these biased instructions to lower courts and attorneys to predetermine the outcomes of cases before they even begin. By framing the sovereign citizen label as active institutional bias rather than administrative procedure, the author arms the trap set by Ex parte Young. To ground this claim of institutional bias, the author presents a real-world example, a 2019 Magistrate Specialty Seminar held at the Michigan Hall of Justice. The seminar included a presentation instructing magistrates on identifying and handling sovereign citizen behavior in courtroom. The legal deduction is straightforward. The author argues that receiving mandatory training on how to process specific litigants creates systemic, predetermined bias. To operationalize this bias, the document cites Title 28 United States Code, Section 455, which governs judicial disqualification. The author pairs the statute with the 1989 appellate ruling Taylor v. O'Grady, which enforces this disqualification standard for bias. This connects directly back to Premise A. If a judge is automatically disqualified by statute but continues to issue rulings, they are now occupying a de facto role. The court's own administrative seminars create an inescapable paradox. Training judges on how to handle sovereign citizens legally disqualifies those same judges from hearing the cases. Zooming out, we can see the completed legal architecture the author has constructed to trap the federal court. The Norton Doctrine dictates that usurped offices possess zero legal power. Furthermore, the Scheuer and ex parte Young precedents clearly dictate that unconstitutional acts of bias shatter state immunity. Combined, the syllogism concludes that the public functionary is stripped of their official character, exists outside the rule of law, and is personally liable for money damages. The document finishes with a direct challenge. Will the federal court uphold its own stare decisis rulings against state actors? The sheer density of this document makes it a highly calculated exercise in weaponizing foundational constitutional law. Ultimately, this calculated strategy functions to systematically deconstruct the very legal legitimacy of the tribunal sitting in judgment.